Hello, Michigan Realtors, and welcome back to another installment of Letter of the Law. Today's segment will discuss the use of escalation clauses and the best practices for you and your client. Now, at the outset, it is important to note that there is no statute or rule governing the use of escalation clauses. Escalation clauses are an industry-created concept. If you call us and ask us a question as to how an escalation clause works in a particular scenario, the only guidance we will have is the language of that particular escalation clause in question. For this reason, it is very important that escalation clauses are carefully thought out and drafted. For the sake of consistency, let's review some of the more common questions that have come up in the context of the following bare-bones escalation clause. Buyers will increase their offer by $2,000 over any competing bona fide offer to an amount not to exceed $200,000. Question 1. What if the competing offer includes seller-paid closing costs or concessions? Now, drafting and using escalation clauses would be much easier if all purchase agreements were the same, except as to price. But of course, that is not the case. A buyer may offer a higher price, but require significant seller concessions. Should the concession amount be deducted from the purchase price of the competing offer? Logically, yes. But if, as here, the escalation clause does not expressly provide for such an adjustment, it is unlikely that a court would impose such an adjustment. Judges frequently remind us that it is not the job of the courts to rewrite our contracts in order to make them fair. Question 2. What if the competing offer is contingent upon the sale of the buyer's home? An offer that is contingent upon the sale of a buyer's home may not be viewed as favorably as other offers. Buyers who must make their offer contingent on the sale of their home may offer a higher price in order to try to convince the sellers that it is worth their while to wait for the sale of the buyer's home. A seller may have no interest in a contingent offer whatsoever, but nonetheless use the inflated price in that offer as a basis for calculating an escalated price. Is this permissible? Certainly. Unless the escalation clause expressly says otherwise, any type of competing offer can be used to trigger the escalated purchase price. Question 3. What if the competing offer also includes an escalation clause? Where there are two competing offers with escalation clauses, the most common question is whether the escalation clauses can be applied back and forth, increasing the purchase price until reaching the highest cap. Now, this is a question that should be specifically addressed in each and every escalation clause. Also, agents need to be very careful when dealing with competing escalation clauses. We are aware of several cases involving competing escalation clauses where the seller claimed that the agent improperly calculated the escalated purchase price. Obviously, sellers are going to be very unhappy if they think that their agent left money on the table. Question 4. What is the status of the contract if the seller accepts an offer with an escalated purchase price and at the same time confirms the escalated price? Now, did the seller agree to sell at whichever is the correct escalated price, or only if the buyer agrees to the seller's calculation as to the escalated price? Suppose it is proven that the seller's calculation of the escalated price is $10,000 too high. Is the seller bound to sell at the lower price because they accepted, or did the seller counter at the higher price? A seller's response can be drafted in a way that makes clear whether the response is an acceptance or a counteroffer. Sellers who want the security of responding with a counteroffer at a stated price need to understand that a buyer is free to reject any counteroffer. Question 5. What if the appraisal comes in at a price lower than the escalated price? Now, many purchase agreement forms do not have an appraisal contingency. If there is not an appraisal contingency, in the event the property appraises for less than the purchase price, the buyer is still obligated to close unless the mortgage contingency is not satisfied. In other words, if the buyer can still qualify for a mortgage pursuant to the terms set forth in the purchase agreement, the buyer is still obligated to close, even if the property appraises for less than the purchase price. And question 6. Can the seller ignore the escalation clause and simply counter back at the buyer's maximum price? Absolutely. There is nothing to prevent a seller from ignoring the escalation clause altogether and simply countering at the buyer's stated bottom line. A buyer who has included a maximum price in the escalation clause has obviously shown his or her hand. That being said, the risks of not including a maximum price are obvious. Even with all of these issues, there is certainly no indication that escalation clauses are falling into disfavor. Escalation clauses continue to be commonly used, but too often there is not enough time and thought put into drafting such a clause. Now, as a result, we have attached a sample escalation addendum that will go out with the release of this video. It is designed to help both buyers and sellers and their respective agents walk through the various issues that should be considered when including an escalation clause in a purchase agreement. While the form is set up with various choices, Realtor forms may wish to make uniform decisions on these choices and revise the language in the escalation addendum accordingly. Now, thank you for all of the great feedback and ideas for these videos. Keep them coming to the email below, and thanks for tuning in to this installment of the Letter of the Law.